Good morning, everybody. My name is Henry Green, and I will be the presiding judge this morning. The other judges are here with me this morning are Melissa Taylor Standridge and Patrick D. McInerney. And it'll be my responsible to get the attorney's appearances. And the first case we have up is 121276, Karen E. Davis versus Fadi, Estephan, MD. Appearing for the appellant is it Matthew R. Bergman?
Yes, Your Honor.
Okay. And appearing for the appellee, is it Brian L. White?
That's correct, Your Honor.
Okay. Now, I will be keeping time. And first thing I would like to know, does the appellant want to reserve any rebuttal time?
Your Honor, I would request 2 minutes of rebuttal time. It's my understanding I have 15 minutes total.
Correct. This is set for 15 minutes. Mr. Bergman, I have it as about 9:04, 9:05. Are you ready to begin with your argument?
I am, Your Honor.
We're ready to hear it. Ready to proceed.
May it please the court, I am Matthew Bergman, and I represent Karen Davis in this matter. We are respectfully requesting a reversal of the district court's findings and a remand to the district court for a full trial on the merits for our client. We believe the district court abused its discretion and was in error on 4 points. The first point that I would like to address is in regard to our request to amend and or supplement our expert witness designation to include Michael Hurwitz, who is an MD. The facts of this case are lengthy, and I'm not going to repeat them, but what I want to focus on for this argument is the time frame in late 2016 and early 2017. Prior to that date, the court had taken the case in piecemeal. There had been sporadic status conferences, and the parties had exchanged initial written discovery, and there had been some initial depositions taken. After those exchanges occurred, the parties believed that the matter was ripe for mediation, and there was significant conversation that a mediation could potentially resolve the case, and that was our belief as well. And because of that, there were certain orders issued in late 2016 and early 2017, wherein the court directed the parties to do that. Now, with regard to the issue and dispute on this point, I do want to reference to a motion hearing held in January of 2017 before the district court. And at that time, our office had learned that our medical expert, Dr. Hurwitz, had retired. And there were significant conversations with the court regarding the status of the case at that time. And I want to be clear to this panel. At that point and in that hearing, I represented to the court that Dr. Hurwitz had retired, that at that time we did not believe that he would be available at trial, that he would be available for use as an expert. And I also represented to the court that we would rely on records of treating physicians, including those at the Mayo Clinic, for our case. However, those statements and that the whole discussion at that point in time was in reference and as a condition to get this case to a mediation.
Counsel, you say you were going to use the records from Mayo's to prove your case. It was my understanding that you represented that you were going to use treating doctors from Mayo's as your experts. Is that not correct?
That's in the record, Your Honor, and there was that discussion, although my review of the transcript is that there was some back and forth, but I am not going to object to the fact that we did state that we would use treating physicians from Mayo. Yes.
As your experts.
as potentially one of our experts, Your Honor. Now, I want to explain to the court, and I'm sure you're asking, what would cause myself and Miss Davis, our client, to believe that the orders and the discussions in early January 2017 were for mediation? Well, I want to explain why. First of all, we had no controlling case management order in the case. None had ever been issued by the court. No pre-trial date had been set. There was no discussion regarding trial. There hadn't even been a pre-trial conference or any discussions regarding final designations, dispositive deadlines, or other matters regarding trial. And again, the context of the discussion was, and the ultimate order of the court was, to have this matter go to mediation, and it was our hope that that would resolve the case.
Let's talk about the order. This is the order, February 14th, 2017, is that correct?
Correct, Your Honor.
And Mr. Bergman, is it correct that you drafted the order?
I did, Your Honor.
And let me ask you, when I read your order, I didn't see it was conditioned on this mediation. Did you, am I missing something? Does the order that says condition, and as far as your expert as witnesses designation, is a condition based upon this mediation that was supposed to follow the order?
Your Honor, that's a great question. And my answer to that would be, it was our understanding that it was conditioned upon mediation. And if you look specifically at the order, there's 4 points. And here's what it says specifically. It says, the plaintiff shall serve upon defendant her expert reports by the date in question, which was February 14th of 2017. Following the review of the expert reports, mediation is to be conducted. The parties shall agree upon a mediator, and upon selection of the mediator and scheduling of mediation, the parties are to notify the court. Now, in further response to your question, that order does not provide guidance as to, I would say, matters regarding trial. We did not view it as an order that would foreclose us from providing supplemental or other designations of experts. It allows us to share upon the defendant our reports so that we can get to a mediation and get the case resolved. That was our intent. And if you look at the order, Your Honor, the reason we take this position is that even to the defendant, to Dr. Estephan, it provides no deadlines or no controlling matters to him as well. And it's a similar order, or nearly identical other than the date change, as to what was previously issued in the case a few months before. Did that answer your question, Your Honor?
Yes, and let me ask you this. Are you saying the order, the way it was written, is it ambiguous about the mediation as far as a designation of expert witnesses?
I'm saying that and again, Your Honor, I can only relate what our understanding was at the time. Our understanding is that we were to share our expert reports with the other side so that we can conduct a mediation, and that we were not foreclosed, and neither party was foreclosed, from making other further designations or supplementations in the future. And if in our brief, we explained that our initial report from Dr. Hurwitz had been disclosed over a year previously to the other side. We had exchanged initial documentation as far as medical records. So our understanding is that it was an order related to mediation, not a final order that would be controlling and potentially serve to extinguish the rights of our client to have a trial on the merits and by a jury of her peers.
You know why I'm concerned is that many times we look at orders similarly as what we look to as far as a contract. I mean, whoever drafts the order, I mean, if it's ambiguous, we generally read it against the drafter. If it's plain on its face, we generally go with the plain meaning. I'm just trying to, for you to help me with looking at this order.
Well, Your Honor, in further response, if you read the order plainly and straightforward, then I don't believe it serves as a final designation of experts. I don't believe it serves as a order that would prepare us for trial. And it was always our understanding that further matters would be taken under consideration before we ever approach trial.
Thank you.
If, Your Honor, and to the panel, in support of our position, and as we've briefed, I would point to several things, including a reference to Canada versus Midway Denton, and then George versus Pauley, which are two cases that we cite within our brief. Now, Canada is a decision of this court and lays out a situation where there was a misunderstanding, I'll say, regarding witnesses. And the court goes to significant length to explain the drastic nature of a sanction that ends a trial, or excuse me, ends a matter based upon the exclusion of witnesses. And if you look at the decision of the court in Canada, it's eerily similar to this case in that not only does the court weigh the potential prejudice, which we think is more towards our client in extinguishing her rights here, but it also talks about the fact that to the defense, and similar to this case, it was a situation where perhaps an additional deposition would be needed. Perhaps some additional steps would be needed to be taken by the court to clarify and set forth a case management order. But all those are things that could have been easily handled by the court before we proceeded to trial. And ultimately in Canada, the court found that it was an abuse of discretion and the sanction chosen by the district court in that case was simply too severe. And and interestingly, and I think very importantly, in that case, they were at a pretrial or trial status. In this case, we had no controlling case management order. There had been no pretrial conference set. We did not have a trial date. And as I explained at the start of my argument, the court had kind of taken this case in piecemeal. There was a lot of work still to do in this case. And as a follow-up to the case law that supports our position, I would also point you to the conduct of the parties in that it was our belief and our understanding that the order issued by the court in February directed the parties to mediate. We worked on that for 7 months to try to get a mediation set. And ultimately it was set originally for late August of that year. Approximately 1 week before the mediation was to take place, we learned that the defendant would not consent or provide written consent for an offer to be made at mediation. And therefore, we immediately got on the phone with the opposing counsel, discussed it, and we moved the mediation date. Then the motion for summary judgment was filed by the defendant. And following that filing, we immediately set a status conference with the court, and we went to work to produce the affidavit and the medical reports of Dr. Hurwitz, which we later filed with the court, yet the court did not accept. And that's important because, again, our understanding was we were proceeding to a mediation because that's what we were required to do by the court. Once we understood the intent of the defendant, we took the necessary and proper steps to provide evidence that shows that there was a deviation of standard of care. And we respectfully disagree with the district court. We believe the evidence of Dr. Hurwitz, including his affidavit and our supplemental designation, should have been adopted by the court, followed by a case management order that could have clearly set deadlines for the parties to follow, and we could have proceeded to trial.
Excuse me, Mr. Bergman. Your time is up for as initially, but I'm gonna give you 2 minutes to wrap up, and then you still will maintain your rebuttal time. 2 minutes to wrap up.
Thank you, Your Honor. The other issues in this case is that the court confined our client, and we believe limited our ability to conduct the necessary discovery. And we believe the statute allows us to take the deposition of any individual who is designated, and we were not provided that right.
And you're talking about the defendant's expert,
or any other evidence that we may needed to take to justify our position. But the statute specifically says that we're allowed to take the deposition of any person, and we believe the district court erred there. Additionally, Your Honor, it's interesting that in this case, we believe there's enough evidence that there's a genuine material of fact standing right now that would pass summary judgment. And in our brief, you'll see that there's something referenced as far as the CRAB criteria, which is the 4 criteria for a diagnosis of multiple myeloma. And that analogy was, I guess, used a lot in this case. And the question is whether or not there was any indication through lab results that Miss Davis actually met the criteria for a diagnosis and treatment of multiple myeloma. We don't believe that's the case, and it's outlined in our brief very specifically, but it's a situation where Dr. Estephan's own testimony sets the standard of care and identifies that he did not have any clinical diagnosis or criteria to identify Miss Davis having multiple myeloma or to conduct treatment. And Your Honor, my time's probably up, and I appreciate the extra allowance to present our argument.
Thank you very much. Mr. White, are you ready to make your argument?
I am, Your Honor. Good morning.
Good morning.
Your Honor, I'm here today on behalf of Dr. Fadi Estephan. Dr. Estephan is a board-certified oncologist who is licensed here in the state of Kansas. He has been practicing, or at the time in question, which was 2011, 2012, he was practicing at Hutchinson Clinic, and that's where he works today. As briefly touched upon by Mr. Bergman, the medical issues in this case surround multiple myeloma. Multiple myeloma is a blood cancer. It's a cancer that affects white blood cells, specifically the plasma cell. It's uncontroverted in this case that, at least as of the time that the case was dismissed, Mrs. Davis had been diagnosed with this cancer and was undergoing treatment for that cancer. This isn't the usual case of delayed diagnosis or failure to diagnose. It's a unique case where plaintiff alleges that Dr. Estephan prematurely diagnosed Mrs. Davis and therefore prematurely treated her. We're here today because Judge Keeley in Barton County granted my client summary judgment based on the lack of expert testimony. When you look at the admissible evidence before the court at the time the court ruled on summary judgment, the decision was straightforward and clear. Kansas law requires or puts the burden of proof on plaintiff to prove both that my client deviated from the standard of care and that my client's deviation caused an injury. More importantly for this case, Kansas law is also clear that expert testimony is required. Plaintiff was given a deadline of February 15th, I believe, 2017, to disclose her experts. As of February 14th, when she did disclose her experts, she disclosed one witness, actually 2, but one was not a doctor, not a medical doctor, and that was Dr. Learn, is how it's pronounced, and he is a treating physician out of the Mayo Clinic.
Mayo. Okay.
Correct. And it was our position, and the court agreed, that based on that disclosure and ultimately based on Dr. Lerm's testimony, where he said, I'm not opining on the standard of care of Dr. Estephan. That was not my role. I looked at the patient at the time I looked at her. I made my decision. I'm not critical of Dr. Estephan. And based on that lack of expert testimony, there was no genuine issue of material fact, and the court appropriately granted summary judgment. And we obviously would request that the court affirm that decision. That's, of course, not the end of the story, as can be seen by Mr. Bergman's argument today. I believe plaintiff's position is, well, the court shouldn't have even gotten there yet, because plaintiffs should have been allowed to untimely supplement their expert disclosures and or complete some additional discovery. There's broad language used, like there was a lot of work to be done, or we had the right to do more discovery. The truth is the only real request that was made, and this wasn't made until March of 2018, of additional discovery, was the deposition of our expert, who was Dr. Mitchell Smith.
What about the plaintiffs arguing that there was no case management order in this case?
Yeah, I mean, was there a document that had the term, the label, case management order? No. The case, again, was filed in, I believe, sometime, I think, September of 2014. There was a period of about a year where written discovery was completed, that we had to file a motion to compel to get discovery responses, or adequate discovery responses, and ultimately some depositions were taken. We get to near the end of 2016, and we have a status conference, and at that status conference, the court does enter an order setting plaintiff's deadline for disclosing experts in December of 2016. Plaintiff failed to do so. And then in January files a motion to extend that deadline out of time. And that's when we really get to the critical, I think, at least as it relates to Dr. Hurwitz, the critical hearing, which is January 23rd, 2017. It was a hearing on plaintiff's motion to extend that deadline. The court found excusable neglect and allowed plaintiff to extend that deadline. And plaintiff and the court referenced the order from February 15, 2017 that came out of that hearing. And I want to be clear to the court, that order, and if you look at it, you won't see defense counsel's signature on it. It was submitted without defense counsel ever being able to review that order. We don't think it was 100% consistent with the court's ruling. And we brought that up to plaintiff's counsel, ultimately decided, because we had the court's minute sheet and we had the transcript, that it wasn't a big deal. And why do I mention that? And I think if your honors go to the actual transcript from that hearing, that lays out very unequivocally what the parties believed and where the parties were at that point. I had, frankly, a client that was frustrated at the delays that had continued to occur in this case. And I went in there with a very specific purpose, which was, if plaintiff was going to get additional time, I wanted an end date for their expert disclosure deadline, because that is a absolutely critical deadline in a medical malpractice case. And then I even asked the court to set a deadline for us, to give defendants a deadline so this case could move forward. And the court actually did, in that hearing, set a deadline for defendants. That doesn't appear in Mr. Bergman's order that he submitted without our permission or our review, but it's in the court's order, it's in the court's minute sheet. If you read that transcript, it cannot be more clear that these were deadlines pursuant to the rules for the parties to disclose experts. This idea that it was some sort of a preliminary deadline is just not supported. We ourselves asked for our own deadline for expert testimony so that we can move this case forward. There were discussions about mediation, and the court did order mediation after the disclosure of experts. And I asked the court, what happens next? And the court says, well, if mediation isn't successful, we'll come back and set a pretrial order, get a trial date set. That's not a preliminary idea. That's a discussion about the case management. At that point, plaintiff unequivocally said, I'm going to rely on treating physicians. I'm going to rely on Dr. Learn. I just need an opportunity to finish my disclosure. Plaintiff said unequivocally, I am not going to rely on Dr. Hurwitz. And it couldn't have been more clear. I frankly asked for clarification. I want to be sure what plaintiff's position is and what they're going to do moving forward. And plaintiff said, and I quote, we're not going to go out and waste more time trying to find another expert. I will tell you on the record, and this is plaintiff's counsel, we are not relying on Dr. Hurwitz any further. When plaintiff disclosed their experts in February, that was consistent with what they told the court, which was they disclosed Dr. Learn. It was a broad, and you could find the disclosure both in the record, and I think I cite to it either in my appellate brief or in my summary judgment brief. I can't recall which. It's very vague. There's nothing in there about standard of care or Dr. Estephan's standard of care, nothing in his medical record about a deviation from the standard of care. And so at that point, it was our position as of February 14th, plaintiff's claim had a fatal flaw. Plaintiff had no expert testimony to support, frankly, either standard of care or causation. As the case did move forward, we ultimately disclosed our expert, and pursuant to the court's order in April, the case languished on a little bit more, and we ultimately decided, based on what evidence existed, to file our motion for summary judgment. There's been argument, either in briefing or otherwise, that, well, that was premature, discovery was not closed. But discovery hadn't been closed, that's correct. But the critical and important disclosures that were critical to our motion for summary judgment had been completed. And that was in February 20, I lose track of years, 2017, I believe. And at that point, our summary judgment motion was ripe and ready to go. From the point of our summary, so if we go backwards and say, plaintiff discloses their experts in February, we file our motion in September of 2017. It's not until 1st November in 2017 when plaintiff says, wait, we want another opportunity. We want to try to supplement our experts. So it's 9 months after their disclosure deadline. And then it's not until January the following year that plaintiff's counsel, frankly, improperly file a supplemental disclosure. And it's improper because while they had a pending motion for leave, that motion hadn't been granted. And so it's for the first time, approximately a year after the disclosure, that we learned that plaintiff now wants a do-over and wants to rely now on Dr. Hurwitz. It's clear from the record that Dr. Hurwitz had not been properly disclosed under KSA 6226. It can't be argued to the contrary, and if it is, it's contrary to the evidence. The disclosure, the attempted disclosure in January was clearly out of time, and for that reason, the standard for which the court, in this case Judge Keeley, appropriately evaluated that was KSA 237C. And that's an abuse of discretion standard, which means for the court to overturn it today, they would have to make a determination that no reasonable person would have taken the view adopted by Judge Keeley. And I submit to this court that his decision and his rationale while living this case for 3 years plus at this point was very reasonable, was not arbitrary. Under KSA 6237, the primary issue that the judge and the court analyzed was, okay, we have an untimely attempted disclosure. Was that substantially justified? And then if not, was it harmless? Those are the two critical issues in evaluating Dr. Hurwitz's untimely disclosure. On substantial justification, plaintiff has never really strongly argued. Certainly he plaintiff's counsel never strongly argued in front of Judge Keeley that there was substantial justification for this untimely disclosure. Frankly, in plaintiff's appellate brief, the initial brief, there was no argument regarding that. And KSA 6237 isn't even cited to, but ultimately what I guess is important for this court is, do the circumstances support substantial justification? And the answer is no. And we go back to the critical hearing of January 23rd, 2017. Plaintiff at that point knows that Dr. Hurwitz isn't on board. Plaintiff's counsel chooses, or plaintiff chooses to rely on treating experts. Had plaintiff said, I had an expert lined up, not available, and so I need more opportunity to find an expert that's not a treater, we may be in a different situation, but that wasn't the case. The plaintiff made a conscious choice to move forward with treating physicians. At that point, plaintiff had had more than 2 years to establish her case, and ultimately decided, I'm going to rely on a treating physician. The only thing that had changed between the February disclosure and the November request for additional time to supplement an expert was that we timely and appropriately filed a motion for summary judgment. And I respectfully submit to this court that the risk of dismissal based on the lack of necessary evidence does not create substantial justification for the purposes of seeking additional expert testimony. If that was the case, there would never be an end to a case. Every plaintiff could get a do-over time after time after time until they get it right. And deadlines, some deadlines are more important than others. I'll admit that. The deadline that is critical, and particularly critical in a medical malpractice case, are expert disclosure deadlines. We had a right to rely on those deadlines, and there's simply no substantial justification for the failure to disclose proper and timely expert deposition. On the issue of harmlessness, plaintiff's counsel argues prejudice in their brief. The term is harmless, and it may be to some a distinction without a difference. To me, there is a distinction in the sense that any amount of harm would support a decision to deny the untimely request. And as the court recognized in this case, plaintiff had ample time and numerous opportunities to obtain and disclose their expert testimony. Back in January of 2017, plaintiff made it clear on the record that they had the evidence they believed they needed to move forward, and asked until February 14, 2017. Then the district court in this case, Judge Keeley, in his order in response to plaintiff's, I believe, November 22nd, 2017 motion, and that order came out, I believe, in February of 2018, found that there had been harm. What was that harm? One, we are already 3 years into this case. Since that disclosure deadline, we had already disclosed our experts. We've appropriately filed our summary judgment deadline. To allow essentially a do-over at this point would have caused continued delay, and that delay at this point was harmful to my client. In addition, it just goes without saying, we had a summary judgment motion on file based on the proper disclosure of expert testimony, which didn't support plaintiff's claim. And to allow a do-over at this point would be harmful in the sense that we had a motion pending. And finally, we had disclosed our experts already. Our defense had now been laid out on the table before plaintiff, and it's frankly improper and harmful to the defendant to allow a do-over at that point. The bottom line is, when the court ruled that plaintiff could not supplement their expert testimony untimely, that was well within the court's discretion. That was very much supported by the record, and it cannot be said that the judge made a ruling that no other reasonable judge would make under the circumstances. I believe I have a couple minutes left, Your Honor, and I want to touch just briefly on Dr. Smith. Again, plaintiff didn't address it much in his initial argument, but it is in the brief, which is we should have had this opportunity to do more discovery. Again, as I said earlier in my argument, I think that argument is really narrowed down to plaintiff should have been allowed to depose our expert, Dr. Smith. It's important to keep in mind, we disclosed Dr. Smith in April of 2017. For the next 3 months, there was no request for his deposition. We file a summary judgment motion in September. That doesn't automatically trigger a request for his deposition. And there's nothing, plaintiff will say, well, really discovery was stayed because we were trying to mediate the case. That wasn't our position. That wasn't our belief. You will not find that in the ruling or the order submitted without our permission by plaintiff's counsel. You will not find that in the minute orders of the court. You will not find that in the transcript of that January 2017 hearing. There was no discussion of staying discovery. In fact, if you go back and look at the transcript, in setting our deadline, the court discussed the idea of us deposing plaintiff's experts once they were disclosed. So this idea that plaintiff thought that discovery was stayed is just not supported by the record. But we keep going forward. We file our motion. No request specifically for Dr. Smith's deposition. Plaintiff seeks an extension of their deadline to respond to our summary judgment motion. No request for Dr. Smith's deposition. The first time we hear that plaintiff wants to depose Dr. Smith is in January 2018, almost 8 or 9 months later. And the first time that plaintiff files anything to request that was in March of 2018. And again, I think my time's almost up, and I would simply refer the court to, in deciding whether or not plaintiff should have been allowed to depose Dr. Smith prior to responding to our motion for summary judgment. That's evaluated under KSA 6256F. And plaintiff never established that burden as it related to Dr. Smith. There's no explanation of why that was needed to respond to our summary judgment motion. And frankly, it doesn't make sense because Dr. Smith was our expert. It wasn't an expert disclosed by plaintiff to support their claim. And for that reason, again, I believe the court made the appropriate decision in saying simply, I'm not going to hold up the summary judgment issue so that you can just depose Dr. Smith. And for all of those reasons, Your Honor, we would again request the court affirm the trial court's decision that summary judgment was appropriate, and also in so doing find that district court in this case did not abuse his discretion on these 2 evidentiary rulings. Thank you.
Thank you. Mr. Bergman.
Counsel, you need to turn your mic on. Counsel?
Mr. Bergman, we can't hear you.
Correct, Your Honor. All right, I didn't hit any buttons, but I'm back on now. Can you hear me okay?
We can hear you fine.
Okay, thank you.
Are we ready for your rebuttal?
Yes. I would remind the court that our initial report from Dr. Hurwitz, along with his curriculum vitae, was produced to defendant's counsel all the way back in April of 2015. They were aware of our theory and how we would proceed with the case. There is clearly differing opinions as to what the orders of February 2017 and what the hearing was to result in. But our position again is that we understood the case was to proceed to mediation before anything else was done in the case. And that's what the court directed us to do. And before that could occur, there was a surprise motion for summary judgment filed. Following that filing, we took the proper steps to contact Dr. Hurwitz, and he was so aghast by these developments that he agreed to provide an additional report and affidavit to support our position. And when you weigh all factors in this case, the fact that the court had taken the case initially in piecemeal, that there only had been initial exchanges of discovery, that there was no controlling case management order, that the matter had not been scheduled for pretrial or trial, that there had been an order from the court directing the parties to mediate. The case was not in a construct where it could reasonably be viewed that the order in February of 2017 was a final designation that would foreclose the ability to further designate or supplement, or for our client to have a trial in front of a jury. I would also remind the court that under 6226E, it's a general rule that at least 90 days before the trial date, you can disclose experts. And certainly from our side, we view that as an applicable statute because the order in February of 2017 did not identify or have any indicia that this would be a final disclosure to either party. And because of that, we believe the district court stepped out of bounds, abused its discretion, and in the infancy of a case, determined that it should be extinguished. And we believe that is going too far. We believe the candidate case supports our position. We believe the evidence in the case, including the court's orders, support our position. And respectfully, we would ask that the matter be reversed and remanded for a full trial on the merits.
We appreciate, are you finished with your argument?
I am, Your Honor.
Okay, we appreciate both of your arguments. This case will be taken under advisement and we'll try to get your opinion out as soon as possible. Thank you very much for appearing here today.